Hello, everybody. On this Monday, February 14th, I'm Spencer Mazyck, and this is the Bloomberg Law Podcast, a series of interviews focusing on trends in the busy legal profession. As part of our series on appearance discrimination in the workplace, today we want to examine if the transgender community or people who do not conform to gender stereotypes are protected from employment discrimination. Joining us in studio for today's discussion is Barbara Hoey. She's a partner at Littler Mendelson who concentrates on employment discrimination and age, race, sex, and disability litigation. Welcome back to the program, Barbara. It's nice to see you again.
Thank you, Spencer.
Okay, so I think it's important for us to begin by defining terms because some of the terms that we're going to use today might be a bit confusing. Transgender, transsexual, transvestite. What do those terms mean?
It's interesting. Transgender actually is a term that refers to all of those groups. It's the wider term that covers anyone who identifies as being a gender different from the one they were born with. Then within transgender, you have transsexual. A transsexual is someone who has a desire to live as a member of another gender. And sometimes transsexuals will actually undergo gender reassignment surgery or procedures to change their gender. Then you have transvestites. Transvestites are people who are not necessarily going to have any kind of surgery, but they're what are more commonly known as cross-dressers. Male who dresses as a female, female who dresses as a male. I think the other misconception that many people have is that anyone who's transgender does not necessarily have to be a homosexual. You could be a heterosexual and be in one of these categories.
Okay, and as you know, there have been many complaints from the transgender community of employment discrimination based on their physical appearance. Does Title VII of the Civil Rights Act on its face protect them from discrimination?
On its face, no. I mean, Title VII prohibits discrimination by reason of gender or by reason of sex.
Because of sex?
Because of sex, yeah.
So then what are some typical examples of sex discrimination based on because of sex that Title VII does protect?
Well, Title VII would prohibit a company from saying, I'm not going to hire any woman who doesn't at least have a college degree for this job, but I'll hire males with a high school degree. That would be classic gender discrimination, if you applied one standard to one gender and not to another for the same position. The issue with someone who's transgendered is they are not claiming that they're being discriminated against because they're a man or because they're a woman biologically. Typically, they're complaining of discrimination because they are a man who might dress like a woman or appear effeminate, or a woman who appears too masculine. So classic Title VII would not apply. However, the law has evolved.
Yeah, I was going to say that there's the federal notion of what constitutes sex discrimination seems to be expanding, I guess, because of judicial interpretation of Title VII. And I guess one of the seminal cases, at least in my opinion, one of the seminal cases is Price Waterhouse versus Hopkins. What happened here that pushed the boundaries of Title VII? Well,
that was the case, and it still is the case that has been used to protect the transgender community from discrimination. Ann Hopkins was an accountant who was coming up for partner. She was denied partnership in Price Waterhouse because some of the criticisms were she appeared too masculine. There were comments on her evaluations, should wear some jewelry and use makeup.
Yeah, I have the quote here, which I thought was pretty interesting. She was counseled to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry to improve her chances of making partner. I mean, talk about being critical of someone's appearance. This was sex stereotyping at its best, was it not?
It was, and also because she met all the other criteria for partnership in terms of the quality of her work product. So when that case was decided, which was in 1989, is 20 years ago now, it made law. And what the court held was that you could not discriminate against someone based upon the concept is sexual stereotyping. Just because you're a woman and you don't act like what we think a woman should act like doesn't mean that you can discriminate against me. And that has been expanded now over the years to protect people who are transgendered. So a male who doesn't appear, quote, masculine enough, or a woman who doesn't appear feminine enough, or who is going through gender reassignment surgery, might be a cross-dresser, might not dress the way the employer thinks they should dress. The courts have gradually evolved to the point where many courts have recognized that that is unlawful now.
Well, let's
under
talk
Title
about
VII.
one case in specific, and the case of Smith versus the City of Salem. This is a case that actually came after, it's a Sixth Circuit case that came after Price Waterhouse,
Yes.
and it involves a pre-op transsexual. What other facts happened in this case?
Well, Mr. Smith was going to be a firefighter. He was diagnosed with gender identity disorder, which is a diagnosed condition, however, not currently protected by the Americans with Disabilities Act. He told his supervisor that he was going to go through gender reassignment surgery. And at that point, the city officials met to decide how to terminate his employment. They basically went on record saying they wanted him to go for psychological testing. Secretly, there were notes that they were hoping he would refuse. And a battle ensued over whether or not he had to go for testing. He refused to go for the testing. He was suspended, fired, and got a lawyer. And
well, I know that there was some back and forth, though, as to whether or not he had a gender identity claim, but I think ultimately the Sixth Circuit found that he had a viable sex discrimination claim. How did they arrive at that conclusion?
Using Price Waterhouse. I mean, this was 2004, so it's about 5 years after Price Waterhouse, and what the court held is that an employer who discriminates against a male because, their quote was, because they wear dresses and makeup or act feminine, are engaging in sex discrimination.
Yeah, and it sounds similar to what the court in Price Waterhouse said. I know that they stated further that we are beyond a day when an employer could evaluate employees by assuming or insisting that they match the stereotype associated with their group.
Exactly.
But tell me this, though. Do these cases open the door, even if it's ever so slightly, to federal protection for transsexuals from employment discrimination?
Well, the cases have made law, and there was an act that was proposed, I believe, either in 2008 or 2009, that would have amended Title VII to specifically protect gender identity from discrimination. It's kind of fallen by the wayside with the changeover and the Democrats losing the House, and I think it's pretty much on the back burner right now. But a number of states protect gender identity.
Well, and I want to get to that first,
okay.
but first let me ask you just this scenario. What happens whenever a man decides that he wants to wear a dress to work at a company where there's a strict dress code that men ought to wear suits and ties, and women, of course, can wear dresses and suits? Does he have a viable sex discrimination claim if he's terminated for wearing dresses?
I think he might have a claim, especially if he can demonstrate that he is wearing a dress because he actually is a transsexual, he has a gender identity disorder. I think a male may not have a claim if he was just being playing some sort of a game.
But really, that's interesting to me, because even though there's a dress code, does that not factor into it at all?
Dress codes are enforceable, and dress codes, certainly companies that wear uniforms, can enforce a dress code, can require the wearing of a uniform. But if an individual is, like Smith, is someone who is suffering from a gender identity disorder and is wearing the clothing not just as a lark or a joke or to be disrespectful, they're wearing the clothing of the other gender because they truly feel that they want to live as the other gender, then I think that individual may have a claim. Of course, every one of these cases turns on the facts. I mean, you can't broadly say.
Right, because I was wondering whether or not courts have routinely upheld the dress code as saying, okay, well, it must be enforced so long as there isn't an unequal burden on the sexes.
Well, there was a case against Harris a couple of years ago where a bartender, female bartender, was fired because she refused to wear makeup. It was Jesperson. And that went up to the Ninth Circuit. And Harris had specific standards for the women who were in the public eye. They had to wear makeup. They had to wear jewelry. It was very specific. You had to wear mascara. You had to wear lipstick. I mean, it was really kind of interesting. And essentially, Harris won. The Ninth Circuit, and that's a very liberal circuit, held that it was not an undue burden on the females to ask them to wear makeup.
Do you think that case law will evolve to recognize that dress code in a person's sexual orientation can lead to impermissible sex stereotyping?
Yes.
Okay.
I think it will, and I think by the time it evolves to that point, we're also going to have legislation at some point on a federal level.
Okay, and as you have mentioned,
Yeah.
we've really only discussed federal laws to this point. So, and you mentioned though that there are state and local initiatives that actually outright ban and prohibit discrimination based on sexual orientation and even gender identity. Correct?
Yeah, I mean, I don't even think of it now as a debate because in our practice, being in New York City prohibits discrimination based on sexual orientation. 13 states, including major states like California, Illinois, Minnesota, New Jersey, prohibit discrimination based on gender identity. And last count, there were 109 cities and counties that prohibited discrimination based on gender identity, as well as sexual orientation. So when we advise our clients, it's almost if the federal law doesn't matter. I mean, you're in New York, certainly if you're in New York City, you have to be aware that you have to be in compliance with your local laws. And New York City certainly prohibits and protects those individuals from discrimination.
Yeah, I mean, and that's if you're in a city or state where there are ordinances that protect. Otherwise, you probably would rely on federal law.
You would. However, so many of our clients, if you're a national company and you have offices in even one state that prohibits that type of discrimination, or one or two if you're all over the map, you're going to probably have a policy that applies throughout the company.
What advice, though, would you offer employers if somebody's in the process of developing a policy, or what advice would you give them to help, I guess, limit their potential exposure to claims of gender stereotyping?
Well, especially if you know there's someone in an office that is either announced that he or she is going to go through gender reassignment, I think there are two things: education and communication. And they really go hand in hand. I mean, the first is education. I mean, you may have to start with educating even your own human resource professionals about what this person is going to be going through, this individual, or if they are a cross-dresser, what they're going to be seeing. If you're going through gender reassignment surgery, you have to talk to the manager of that individual, manager or managers. You also have to talk to his or her coworkers. And I've had clients who've actually retained trained professionals to come in and talk to a department about what their coworker is about to go through. There are entities that will, basically entities that support the transgender community that send out speakers that will come in and do training. And it's really eye-opening because the employees don't understand and they get to ask the questions they need to ask. Often you don't have the individual there for this training.
Right, of course not.
You know,
Yeah.
and it all is out in the open. And so that you avoid the rumors, the whispering, the laughing, the misinformation. So it's about education. And then, again, going hand in hand, communication.
In an ideal world, though, wouldn't it be great if employers just promoted and embraced diversity in the workplace? Because like you said, it really could lead to the retaining and hiring of the best and the brightest.
I think that is an ideal world. I don't think we're there yet.
No, not at all.
I saw an article just last week, statistics collected by the report of the National Transgender Discrimination Survey. 47% of transgender applicants experience an adverse reaction to the fact that they are transgender. This is February of 2011.
Wow.
26% lost a job because of their transgender status. And wait for this, 90% have experienced harassment or mistreatment at work. 90%.
90% of transgender folks have experienced harassment at work.
90%.
Even though, like you said, there are several states and local initiatives that actually prohibit discrimination based on gender identity, they still have experienced that discrimination.
Yeah. So, you know, we advise our clients always that compliance is better than being, quote, sued or brought up on charges. So education, making your employees and your managers aware of what the laws are, and then basically making sure that you can employ everyone on an equal footing, and that if you have a transgender employee, that he or she, they have to do their job. They have to comply with whatever the rules of conduct are in your workplace. They have to perform. But the fact that they are transgender should not, in and of itself, be the cause of stress or mistreatment at work.
All right, well, we're going to have to leave it there, but we really always appreciate you joining us because you share such great insight, so thanks so much for being here.
Well, thank you, Spencer.
When we come back, our spotlight on contributed content. We'll be back in a moment.
Digital technology has transformed the way we live our lives. We can access any piece of information at any time from anywhere. We can share ideas with thousands of people instantly. Staying up to date with breaking news and events is easier now than ever before. All this lets us keep pace with the world in real time. Yet, have any of these innovations been applied to the way we research and practice law? Starting today, the answer is yes. Welcome to Bloomberg Law, the first and only real-time research system for the 21st century legal practice, created by the leading provider of data and information services. A single search feature with access to legal, news, and company databases provides you with powerful legal research results and a holistic view of your clients, filtered so you know the information you receive will be relevant every time. Customizable legal, financial, and news alerts keep you ahead of your clients and in tune with their world. An integrated workspace allows you to organize your results by client, by urgency, by topic, however you want it, and to share those results with people on your team. Log in now to experience Bloomberg Law.
So now it's time for our Spotlight on Contributed Content. This is a segment where we highlight an article that was featured in one of our Bloomberg Law reports. Today's article was co-written by Douglas Halpert of Densmore & Scholl and Michael Stegman of Conan & Patton. The title of the article is "Should I Stay or Should I Go? Tax and Immigration Considerations for U.S. Permanent Residents and Citizens." In the article, the authors examine the tax and immigration consequences that flow from multinational executives, managers, and investors' choice of residence and their procurement or abandonment of U.S. immigration status. This article was very well written, and you can find it in today's issue of our Bloomberg Law reports, Labor and Employment, on the terminal at LELRGO or at BloombergLaw.com. Articles are contributed to us for publication by practitioners, law professors, and other legal experts. To find out more about how you can contribute, please visit BloombergLaw.com. A special thank you to Douglas Halpert and Michael Stegman for that contributed piece. And again, our thanks to the wonderful Barbara Hoey of Littler Mendelson. Bye, everybody.